our third panel. Each witness has been asked to make an opening statement of 5 minutes. We shall hear from the witnesses and then turn to questions from the senators. With us in person at the table, I wish to welcome Nicholas Marcus Thompson, who is the Executive Director of the Black Class Action Secretariat. Hugh Scher, Human Rights and Constitutional Lawyer. And Richard Sharp, who is the Director of Black Equity Branch within the Centre for the People, Culture and Talent, Treasury Board Secretariat of the Ontario Public Service. I now invite Mr. Thompson to make his presentation, to be followed by Mr. Scher and finally Mr. Sharp.
Thank you very much. Thank you very much, Chair, for that introduction. I appear before you today in two capacities. First, as the Executive Director of the Black Class Action Secretariat, which is a non-profit organization that is representing tens of thousands of employees of the federal government that identify as Black for decades of systemic anti-Black discrimination in the federal public service. Second, I appear before you as President of the Union of Taxation Employees, Toronto North, representing approximately 1,400 employees at the Canada Revenue Agency. In this capacity, I have supported many employees with their complaints to the Canadian Human Rights Commission. I've also experienced firsthand the various barriers and obstacles to process and adjudicate complaints of all kinds before the Canadian Human Rights Commission, particularly race-based complaints. I would like to begin by acknowledging that anti-Black racism is deeply entrenched in all of our public institutions, including the Canadian Human Rights Commission. This has also been acknowledged on many occasions by the different leaders of our public service, from the RCMP to the Treasury Board and throughout the public service. As a matter of fact, the Prime Minister of Canada has repeatedly highlighted the concerns about anti-Black racism and systemic discrimination throughout our public services. As an elected union representative, I have observed rampant anti-Black racism at the Canada Revenue Agency. This systemic and institutional nature of such complaints make them difficult or impossible to address institutionally or as part of the grievance process oriented towards individual grievances. The same is true regarding individual complaints before the Canadian Human Rights Commission. Over the past 50 years, the Commission has done nothing to effectively address the widespread practice of Black employee exclusion in hiring and promotion throughout the entire federal public service. Such failures call into question the mandate and the capacity of the Commission to address such systemic complaints. The fact is, internal race-based discrimination at the Commission itself represents a major obstacle and has resulted in a loss of confidence of the Commission to meet its mandate. Following the grievance process, I often advise employees to submit a complaint to the Commission. Therefore, this submission is based on those experiences. Employees often experience long delays in receiving an initial response from the Commission. Race-based complaints are almost always denied, leaving these employees broken and without justice. These complaints are frequently struck at early stages of the process before full information or evidence is learned by the Commission. Often, when advised by the union to submit a complaint to the Commission, employees are afraid, opt not to, citing lack of trust in the Commission. To put this into simple perspective, employees are fearful of utilizing the complaint process at the Canadian Human Rights Commission because it triggers more trauma. You have to retell your story over and over. And employees rather salvage the little hope that they have and the little strength that they have left to cope with the trauma that they experience in federal workplaces. In 2020, after going through all of understanding the Commission and the lack of process in terms of justice at the Commission, I mobilized workers starting at the CRA to understand their experiences as it pertains to anti-Black racism. And as I spoke to workers across the federal government, the common theme existed, that Black employees were left in entry-level positions while being exceptionally qualified, some with multiple degrees. They're retiring broken in the same position after decades of loyally serving the government and people of Canada. And when I went to the commission, I thought I would find something different at the Canadian Human Rights Commission, created under legislation to protect human rights. And I was deeply wrong. Employees at the commission told me that they experienced the discrimination at the commission was so strong. Some had to take sick leave for a lengthened period of times. Some resigned from the commission due to the rampant nature of anti-Black racism. And they share the similar experience as employees in the rest of the public service. And that is, at the commission, Black and racialized employees are in entry-level positions, doing all the screenings, and that white employees held all the management positions all the way up to the top. As a matter of fact, there has never been in the history of the commission a Black commissioner, a Black chief commissioner. And the commission was established in somewhere in 1977. So that in itself is appalling. But they tell me about this toxic culture at the commission, and that those experiences at the commission, what the employees experienced, showed it. It gave me more perspective on the employees on the outside who were filing complaints to the commission. Because on the outside, here I am experiencing with workers, their complaints being dismissed, them being afraid, and we're still encouraging them to try to use the commission, but their lack of trust in the commission. And then on the other side, the employees of the commission facing discrimination. And they're saying as well that when they make a decision on race-based complaints at the commission, and that complaint goes up to their usually white supervisor, how those complaints are disproportionately rejected. So the broad-based experience of anti-Black racism throughout the federal public service led us to file a historic class action against the entire federal public service. None of the mechanisms, the grievance process, the federal board, the Human Rights Commission was able to address systemic anti-Black racism. As a matter of fact, it perpetuated to a point that it was so hurtful to workers with no redress. Like Caroline, who worked for the RCMP for 37 years and never received a promotion. Or other employees who worked for up to 50 years, still working, unable to retire. It's really, really appalling. And it's in key institutions that workers rely on for justice. Workers rely on for leadership, like the Treasury Board of Canada. Black workers working on the mental health program there, all of them fired after they raised concerns of anti-Black racism. And it's the same Treasury Board that made the ruling that the Canadian Human Rights Commission was discriminatory towards Black employees. So we have this vicious cycle within the federal public service where there's no accountability. Wrongdoers are often either transferred when it comes to discrimination or promoted, as we've recently seen in the case where a senior executive at the Canadian Human Rights Commission was promoted less than a month after this finding of discrimination at the commission. Less than a month. And promoted to where? In charge of racism, anti-racism for the entire federal public service. So where do workers turn to if we can't turn to the Canadian Human Rights Commission? So we'd like to make some recommendations. And a root part of the problem here is the Employment Equity Act. Because the Employment Equity Act groups all racialized people into one group, federal employers have consistently excluded Black employees from promotional opportunities because it's not defined. So there is probably one or two racialized group that is the government's preferred employment equity groups that the government, throughout the government, consistently uses. When we filed this class action in 2020, there were 99 Black executives throughout the federal public service, none at the Canadian Human Rights Commission. 99 out of 6,200 executives across the federal government. And federal employers have consistently told me the problem is the Employment Equity Act. We cannot tailor staffing and competition for Black employees because the act does not allow us to. When I presented a plan to develop Black employees utilizing the staffing mechanism in the public service, they said that it would be discriminatory to white employees if you target employment to Black employees. So we are proposing that the government amend the Employment Equity Act to create a designated group for Black employees apart from racialized employees. That's the only way we'd be able to address Black employee exclusion in the federal public service. This would prevent federal employers from hiding behind the visible minorities category and excluding Black employees intentionally. You'll hear from witnesses like Bernadette Becci, who has multiple degrees, and the sister is unable to move ahead at the commission. It is just appalling. It is hurtful. It is not the Canada that we're proud of, the multiculturalism and diversity. So we're seeking an amendment to the Employment Equity Act to designate Black people as a separate category. And that's when staffing issues at the commission, there would be a designated category. So when there's a gap for Black employees, the commission would have to hire qualified, competent, merit-based Black Canadians just by looking at the Black category. Secondly, we would recommend the creation of a direct access model for adjudication so that complaints can go directly to the tribunal. Next, we need to have accountability. We do not trust the commission to be accountable or the rest of the public service to be accountable on these matters of race. So we are calling for a Black Equity Commissioner to be able to investigate systemic anti-Black racism at the commission and throughout the federal public service, holding the public service accountable, and would have the ability to take the required steps to eliminate and to prevent this type of discrimination from
Mr.
continuing.
Thompson, I'm sorry to interrupt, but I've let you speak for almost 10 minutes, and we have the other witnesses and the questions. Maybe senators, we could ask some of the questions, and but if you don't, complete your testimony, you can give us a written submission. I apologize, but we have a list of senators who want to ask questions. Thank you. Mr. Sher.
Thank you, Madam Chair. Thank you, Senators. I appear before you together with Mr. Thompson because we wish to highlight the concerns around the commission structure, make recommendations as to what should be done to try to improve the system, and try to address sort of how we've gotten to where we are that's given rise to this panel. I have 4 points to make. My first point is that the Human Rights Commission federally is broken beyond repair, and that the only option in terms of a means to ameliorate the situation is to resort to a direct access model of adjudication through a tribunal system, much as is being done in Ontario and in British Columbia. Secondly, I would note that the findings of discrimination as against the Human Rights Commission within its staff internally undermine fundamentally the moral authority and the legal mandate of the Commission to meet the concerns of Canadians, including Black Canadians, regarding the ability to fairly and effectively adjudicate and address and process human rights complaints brought by this and other communities. Thirdly, I would note that the fact that the Commission has failed abysmally to meet its mandate to address systemic, discriminatory, and institutional barrier concerns represents a significant failing on the part of the Commission in terms of negating any ability to effectively address systemic and institutional barriers experienced by Black Canadians and others across the federal domain. And lastly, I wish to highlight that I am concerned that the reason for the finding by Treasury Board in this instance of discrimination is effectively being made to target and to harm the prospects of the Black class action lawsuit that Mr. Thompson and so many others have courageously brought forward. And I say that for the following reason. The argument of the government is that the Commission and others have the mandate and the ability to address concerns of systemic discrimination and harassment. And by effectively finding through a grievance process that there's been discrimination, the government is seeking to rely upon that finding as a means to preclude the class action from proceeding through the court process. And in my view, that represents an unfair and bad faith mechanism in terms of the use of that process, in terms of the findings made by the tribunal. I come to this panel with the following recommendations. Number one, resort to a direct access complaint-based model for human rights complaints as in BC and Ontario. The reservation of public resources to assist and provide legal representation for complainants before the tribunal in order to ensure that they can meaningfully and appropriately advance their complaints. Second, to ensure the employment equity amendments that my friend Mr. Thompson has recommended relative to the visible minority category of the Employment Equity Act, over which the Commission to this point maintains jurisdiction and oversight. The need for a specific and separate category for Black employees has never been clearer. And just as the urgency that's given rise to this panel is clear, so too is the need for change. But the problem is that this need for change has been in place and necessary for decades. Previous to this presentation, we heard about the recommendations of the Justice Laforêt expert panel review, which recommended a direct access model back in 2000. More recently, in 2020, former Human Rights Tribunal of Ontario Vice Chair Mark Hart prepared a several hundred-page report at the request of the Commission, which basically found that the Commission was failing in the meeting of its mandate in several key respects, including in terms of applying improper analysis as part of the processing of complaints, which effectively ended complaints before they began. The failure to apply the proper prima facie discrimination analysis in the context of the assessment process was extraordinarily detrimental. It meant that people were consistently reviewing over and over again their complaints, reliving their trauma, and getting nowhere further in the process. The Human Rights Commission has failed in terms of its ability to resolve complaints in a meaningful way, and so many of them get dismissed before they have the chance for adjudication, and those determinations are made before any full canvassing or assessment of evidence is permitted. Given those recommendations, I highlight again the urgency of now. I highlight again the need for these changes. And I highlight again the importance of ensuring that in implementing a direct access model, that a process of adjudication is maintained that does not encumber the same barriers of delay and of adjudication hurdles that the present system epitomizes. I urge that the moral authority of the Commission, which to this point has been significantly undermined, requires that the Commission's mandate be limited to a more focused role around the administration around systemic discrimination issues, education and training issues, and other public information sources. That would give the Commission a specific focus, and it would enable the Commission to be able to do something based on a level of knowledge, understanding, and expertise that it presently has neither the resources nor the time to do. And lastly, I would agree with my friend Mr. Thompson that there is a need for a Black Equity Commissioner or some means of oversight to ensure that the mechanisms being applied at the commission or at the tribunal are not effectively impeding and imposing additional barriers to equality and to meaningful adjudication of real disputes for Black Canadians. Subject to your questions, those are my submissions. Thank you, Madam Chair.
Thank you very much, Mr. Sharp.
Good evening. Bonjour. Je vous remercie de m'avoir.
Thank you for giving me the opportunity to present on this important subject. I will be presenting recommendations aiming to better support human rights for people of African descent who live and work in Canada.
First, the disclaimer. I'm not speaking on behalf of the Government of Canada or the Ontario Public Service, where I am currently employed. To jump right in, Black and racialized communities have always known they will not receive timely and fair access to justice if they bring race-based complaints to the Canadian Human Rights Commission. Hence, many deserving complaints are never referred to the commission. People just don't come forward. The commission has always served not only as gatekeeper of the status quo, but also the place where race-based human rights complaints go to die, either rejected at disproportionately high rates or left to languish for years until people become too tired to fight anymore. That has already been discussed and shared with a number of presenters. Its own data proves this to be true. For example, only 33% of race-based complaints were accepted by the Commission between 2018 and 2022. What happened to the 67%? I guess we will never know. People had to go home without having redress. Over the decades, the impacts on Black and racialized communities who are victims of institutional anti-Black hate and anti-Black racism have been profound. Loss of employment, loss of income, stress-induced mental and chronic illnesses, that feeling of hopelessness, that there is nowhere to go for help. On a personal note, all 8 of my immediate family, my brother, my father, my mother, my sisters, have been victims of anti-Black racism in employment, education, and interactions with law enforcement. This has defined our existence as Black people and as a family in this country. Over my 25 plus years as a union representative and human rights advocate, I've counseled people not to go to the commission with complaints of discrimination because it has been a notoriously futile effort. Before data was being collected officially, communities were unofficially collecting that data to let people know what the deal was. In 2019, the Federal Black Employee Caucus, a group I co-founded with my intrepid colleagues, met with the then Chief Commissioner and her senior staff. The message from the Federal Black Employee Caucus, FBEC, was simple. The CHRC is irrelevant as an institution because it does not uphold the very purpose of its existence, which is to safeguard human rights for its population, in particular Black and racialized people in Canada. In March 2020, the Commission invited racialized organizations to consultations on how to improve the complaints process. We compiled a list of recommendations along with those community organizations that was delivered to the Human Rights Commission on March 26, 2020. Later that summer, Human Rights Commission employees, Black and racialized employees, alerted FBEC of instances of anti-Black racism within the Commission. Like good public servants that we were, we went to the Commission leadership and we asked the leadership to take a look at this because those concerns were damaging and it was difficult for us to maintain a working relationship to try to address issues with respects to a little working group that we put together to look at disaggregated race-based data that we were asking to have collected as part of the complaints processes. We wanted to understand what was going on from a data, results, and performance perspective. After raising those concerns, they were not adequately addressed. And as Nina Simone says, you must leave the table when love is no longer being served. So FBEC left that table, that relationship, in the fall of 2020. At the same time, FBEC quietly informed the leadership at all levels of government that there was a problem brewing at the Canadian Human Rights Commission. Again, by doing this quietly, the hope was that people would resolve this in a way that nobody would, get hurt and there would be no reputational damage. We counseled that these revelations would be explosive, damage the Canadians' confidence in the institution, hurt Canada's brand, and not to mention the employees in question. As far as we could see, as far as we could tell, nothing was done. So now the chickens have come home to roost. Over the last 3 years, the CHRC did make efforts to address some of these issues themselves, modernizing their complaints process and so on, and developing an anti-racism action plan. What are the results? What are the measurable changes that we have seen with respects to the outcomes for Black and racialized people who bring complaints to the Commission? How is the Commission done in ensuring its leadership and staff are reflective of the racial diversity that is Canada? It is not just that the Human Rights Commission needs to be scrutinized here. My observations, and this is coming from Richard Sharp here, is that all the institutions that enable the dysfunction within the Commission and disable it from living up to its stated purpose are implicated. So I'll jump right into recommendations here because I think that's what people really want to hear. My first recommendation is that a national inquiry on anti-Black racism in federal institutions be instituted and supported by both houses of government. Leadership in our institutions continue to fail people of African descent in Canada. I echo the calls for rights-based, human rights-based complaints, race-based complaints to be sent directly to the Human Rights Tribunal. People should have their cases of discrimination heard, not summarily dismissed. And that's why, and I also echo, and a number of us have been calling for this from community, an independent expert on anti-Black racism to investigate the Commission's practices as is definitely required. It's a no-brainer. This is something that we should have put in place a long time ago. You can't only have people who enjoy generational white privilege as the sole stewards of the soul of a racially diverse nation. Bad things happen to us when this kind of dynamic is left unchecked. This has been decades of this dynamic being left unchecked. And last but not least, a Black Equity Commissioner. We've been talking about this. We need this. This is a legacy building piece for Canada. There are not very many results for the UN Decade for People of African Descent. We're at the end of that process. Intergenerational decline of Black people in this country is directly linked to the institutional structures that maintain anti-Black racism in every single aspect of our Canadian work life. The UN has stated this, our own statistics, reports, studies, in all aspects of Canadian life have shown this to be true. And so to close, this is not an if anti-Black racism exists within our institutions, including the Commission. It is how bad is this cancer? How bad is this illness? And can we do what's necessary to heal it? Canadians may be shaken by the revelations that the Canadian Human Rights Commission is not what they thought it was. But now that we have the data, we have the evidence, and we have the verdict, The challenge for us now as a society, as institutions, is whether we have the level of ambition to
Mr.
achieve
Sharp,
results for
Mr. Sharp, I'm
Canadians,
sorry
even
to-
for those who are black.
Mr. Sharp, I'm sorry to interrupt, but we have senators who have questions, if you can.
That was my last sentence.
Okay, thank you. I'll let you finish.
Okay. It was my most impactful sentence too. So I got to say with the same kind of bravado, if you will allow me. Now that we have the data, the evidence, the verdict, the challenge for us is whether or not we have the level of ambition to achieve results for Canadians, even for those who are black. Thank you very much for the opportunity. Merci beaucoup.
Thank you very much to all our witnesses. So, senators, as is our practice, so we now turn to questions. Just sort of recognizing the time, I think we'll have time for one round. I will start with the Deputy Chair, Senator Bernard, to be followed by Senator Omidwar.
Thank you, Chair. Thank you to all of our witnesses. I will ask two questions. The first question would be to Mr. Thompson. If you had other recommendations on your list, please share them now. My second question to all three witnesses. You've all mentioned a Black Equity Commissioner. If you could tell us in your ideal world, what is that? What would it look like? What are you recommending here? Thank you.
Thank you very much. So on the first question with regards to any additional recommendations, my final recommendation was that human lives have been significantly impacted as a result of actions at the Commission, as well as throughout the public service. Although the grievance finding provides a declaration, these employees continue to suffer. There must be some type of remedy for these workers who are impacted, workers who've served decades and still in their retirement, they're coming out and telling us about the trauma, the hurt, and the pain. So there must be compensation and meaningful redress for employees impacted by systemic discrimination and the failure to remove barriers to the full participation of Black employees at all levels. And your second question, Deputy Chair, Madam Deputy Chair, if you can clarify that, it's about the Black Commissioner.
What I'm asking, if you could tell this committee, what does that mean to you? So we've heard the term, but we don't have a sense of what let's assume we don't know what you mean by that. So what would a Black Equity Commissioner, what would that person of that office do?
Madam Vice Chair, if that's helpful. I would be happy to speak to that point if it's helpful.
Yeah.
Yes. So I've asked that question of all three of you. Whoever would like to speak to it, please.
Why don't I start, if I might, if you don't mind? We know from our experience in Parliament the effectiveness of the Auditor General in terms of their capability to review the systems, policies, and practices, how money is spent, how systems are operated, and how the mechanisms of government are made to work or not. The same kind of seriousness needs to be brought to bear in terms of reviewing, assessing, and rectifying institutional barriers and systemic obstacles in terms of how they impact Black participation and the participation of other groups within the federal public service and across the federal workforce and service delivery system. In my respectful view, the appropriate way to do that is to have a specialized expert, knowledgeable about anti-Black racism, but with similar powers and authority as the Commission is deemed to have relative to employment equity review, but has the ability to go in across the federal public service and to review systems, policies, and practices with a diversity, inclusion, and equity lens, with a anti-Black racism lens, in order to assess to what extent the mandates and the objectives stated by the government in each of its various departments are in fact giving rise to measurable results, and where they are not, to take concrete action in terms of recommendations that can ultimately be implemented and enforced through Parliament. That's my view of the Black Equity Commissioner. It would enable the ability to enforce Canada's international obligations through the concrete review and assessment of domestic policies and practices in a way to identify the barriers, identify what solutions have been implemented or not, and make concrete recommendations, just as the Auditor General does, as to how these barriers of institutional racism and systemic problems can be removed and rectified. Thank you.
In addition to that, there's a significant distrust in the public service, particularly amongst Black employees in terms of any type of investigation or systemic barriers that they face. And a big part of the challenge and why we're unable to address anti-Black racism is that the same leadership, the same public service that has carried out acts of discrimination that have harmed employees is the same public service leadership that the government has called on to address the issue. So that's why we'll see things like the clerk's call to action never being implemented to sponsor, promote, and support Black employees to leadership position, because the public service of Canada does not believe that there is a problem of anti-Black racism. All of their measures are performative by nature. Therefore, a Black Equity Commissioner will do exactly what Mr. Scher has indicated, that would, we're seeking a commission structure that is fully funded, that has the power to police the public service, because we do not trust the public service to police themselves. Those who have oppressed workers for decades, now responsible for that change. So we're seeking to have that neutral third party that would have the training and expertise in terms of addressing these issues.
I agree with both Mr. Scher and Mr. Thompson on their recommendations. I would also add that I think the question that you may be asking, Senator, is that people have a lot of different ideas of what a Black Equity Commissioner would look like. And I actually, in some of the corners that we have been talking with, see the potential of a Black Equity Commissioner to be broader than just public service, but also look across Canada throughout our various institutions and functions. Because there are some aspects within the Human Rights Act that don't adequately cover discrimination in service provision, for example. So, you know, we don't want things lost because we're just focused strictly on federal institutions. I think people know that anti-Blackness, if it is so baked into every fabric of our country, foundational to our country, that we need something institutional to be able to try to check that over the next couple of decades. And something that's not performative. I think there's a lot of concern that an order in Parliament, putting something like this in place, an order in Parliament, would just be for show and not be as effective as people might like. But that's why I think you need to have, to some extent, a public process and an accountability, transparency and accountability mechanisms built in so that it can be real. You know, we're to some extent, we're blue skying here because we're asking for something to be put in place that's never been conceived, never thought of before. Canadians just seem to be coming to terms that anti-Black racism exists, and it takes this particular issue with the Canadian Human Rights Commission to shake people, sort of our government version of a Floyd effect moment, into thinking about what we can do outside the box and at an institutional level, so that it's not performative, not a program, not an activity, but an institution to deal with this stuff with the intention of doing it for the long term.
Thank you. Senator Umedwar, to be followed by Senator Annett.
Thank you, Chair. I must express my dismay at what I have heard. It is unfortunate, and your evidence is compelling, and thank you for being here with us. I'd like to zero in on the direct access model. You have all talked about it. In 1992, I think 1992, as co-chair of the Ontario Human Rights Code Review Task Force, which I co-chaired with Mary Cornish, we made the exact same recommendation, 1992, that direct access model is the way to serve the public. And we made a recommendation that, in fact, direct access model should not take away from studies and on systemic issues and reviews. BC has a direct access model. Ontario now has a direct access model. Are you seeing in what they are doing, are you seeing evidence of real improvement, or is this again, as what Mr. Sharp has called, performance versus substance?
Can I start with that? All right. What I would say is that there is some difference, and the reason for that difference is that it enables a direct ability to apply to and to potentially adjudicate a complaint, which is not something that can happen under the present system because there's no direct carriage of the matter by the individual complainant. In other words, the commissioner is the one that has carriage of it, and the commissioner will either carry it or often will simply drop the ball.
And do you have any evidence from BC and Ontario, for instance, although Ontario is new at this, that in fact Black complainants in the Ontario system or the BC system are getting heard in a more accessible manner?
What I would say is twofold. Number one is that in part, yes, there is and has been a number of cases at the Human Rights Tribunal in Ontario that have addressed systemic and other issues of concern around anti-Black racism. But what I would also say is that what also happens, and a concern we have, is that the tribunal itself builds in its own gatekeeping functions and will enable complaints either to be automatically dismissed if they aren't believed to meet certain basic requirements, or alternatively will be subject to summary dismissal application processes on almost a routine basis. And that is problematic, and it's happening more and more often, but frankly, it's largely happening as a resource management issue. Because right now, I can tell you the commission, especially post-COVID, is basically implementing this almost de facto as of course for almost all complaints, because it's so bogged down and backlogged. Right now, it takes 8 months to really issue a complaint with the Ontario Tribunal.
And that is my concern, that a recommendation about the direct access model without the words adequately resourced is going to get us into, other challenges and issues. So I wonder if you would agree that if and when a direct access model is implemented, it should be adequately resourced by the federal public.
Absent that, it would be completely ineffective.
All right,
I agree with
thank you. Mr. Sharp, I have a question for you. You talked about the experience of racism, anti-Black racism, in the federal public service. In your experience, your own or that of your network, do they experience it? Is it overt or covert racism? Because governments have become sophisticated in using language and protocols and processes that you can hardly see, at the end of the road, but it's there. How have your members experienced it?
So, in the federal public service, the Black exclusion and denial of opportunities, the racism is very subtle, but it's entrenched in what appears to be normalized and generic processes. So, to put it quite simply, we take the Black and brown and racialized out of our processes and then wonder why we don't hire any Black and brown people through our processes, or they don't advance. We set standards of hirings that oftentimes have the archetype of someone who's, comes from a certain socioeconomic background, oftentimes racialized background, being white, blonde, and blue-eyed. That is the archetype of the model bureaucrat, the model public servant. Someone like me, with the hair is not necessarily seen as a good fit for certain roles, in particular leadership. So it's to put it lightly and to put it very, very bluntly, I think you're exactly right. Very subtle, but it is so normalized. And this is what the UN said in its report to Canada after assessing the state of people of African descent here in 2015, 2016, that report to Canada in August of 2017. So it's so normalized that people just don't recognize it. So, yes, it is definitely, it's one of those things that we have to, when I talk about Black inclusion within the public service, is looking at all of our processes, our HR processes, our management processes, our education processes. Determine that.
I want to ask a question of Mr. Thompson before our very august chair cuts me off. Mr. Thompson, in your opinion, does unconscious bias training work?
Thank you for giving me the hardest question, Senator.
No.
The challenge is that unconscious bias, the term is now being used to excuse bias and racism and discrimination. I did not know that I was discriminating against you. I did not know it was my unconscious bias. Well, that is only further perpetuating the discrimination and the hurt and harm towards Black Canadians, and in this case, in the federal government.
Thank you.
Thank you.
Senator Arnett, to be followed by Senator German.
Thank you, Chair. This question is for, first, I have two questions. The first one is for all three of the witnesses. And witnesses, you've painted a very bleak assessment of the situation at the Canadian Human Rights Commission. It's one of abject failure. It's failed abysmally, as Mr. Scher pointed out. You are thinking of separating the commission from its work and only allowing it to do education, class action. Why would you have any confidence in that organization that they could do that any better than they've done the protection and promotion of human rights? I'm shocked, actually, to hear you say that. It seems to me there's not much of a remedy to fix what is so broken and is so deep-seated in the bias, either conscious or unconscious. That's the first question. The second question, I want to build on what Mr. Scher said, and I just want to make sure I've got this right. Mr. Scher, you're saying you could use the Auditor General as a model. So the Auditor General is an independent officer of Parliament. The salient feature of that is that the Auditor General reports to the Senate and the House of Commons, the two houses of Parliament, the legislative branch of government, not the executive branch of government, which I think is an important thing. So I like the model that you're putting forward. You see this as being a place where there's an education function, perhaps a mediation function, certainly an investigative function, a compliance function, an accountability function, and a large public education function, as I understand it. And I believe you're on the right track here. And that the fundamental notion is that if something isn't measured, it isn't going to happen. So that kind of robust accountability embodied in a commissioner, an equity, Black equity commissioner, to do this work with significant funding and a robust mandate. I like all three witnesses to answer that question. Is that what you're proposing?
It is, sir. It is, and I think you're right on in terms of what you're encapsulating as my recommendation. I think it's important that the commissioner report directly to Parliament. I also think it's important, and there will be, I think, a level of reporting to the executive in that context. There's also, as you've indicated, a educational and an accountability mechanism and measure to that, both in the media, in the public parliament forum, and elsewhere, as well as through the report to parliament. So I think those elements are helpful. And I know certainly we've had effective Auditor General reports that have truly measured accountability and affected change. And it's, to my view, the only mechanism I can see of the existing mechanisms that may be able to root out the harms and to try to provide the level of accountability required, number one. In answer to your second question, I would say that what I think we're suggesting on the second recommendation, I agree with you. As I said at the outset, the Human Rights Commission in its present form is broken beyond repair. That was my first line. It's not a line, it's a reality. Number one. Number two, what they did in Ontario was that they effectively changed the mandate of the commission, and they took out, it was different people doing different functions, right? So it's a different entity now. And its entity is really more about education and information and occasionally intervening to assist complainants, but they are not an actual driving force. And to the extent that there could be a focused mandate and a focused budget with focused specialized personnel, for example, to take on systemic discrimination complaints, some things that frankly are beyond the scope and capability of most individuals, and frankly many organizations, just the cost alone. That would be one thing, but I agree, it's by no means guaranteed that unless there's substantial modification to the institutional structure, personnel, and mandate of such a commission, I agree with you, it would be ineffective and unable to meet the mandate that I'm suggesting. So I agree with that. It would require a fundamental revamping of the commission and nothing like what we have in the present form.
Thank you, and I'd like the other witnesses to comment on as well.
I don't have any further additional comments than what Mr. Scheer has shared on that point.
Yeah, the only thing that I would really say is that, yeah, it's been a failure, but it's been mostly a failure, partly of function, but also it's the people. Mm-hmm. If you have people who make up a demographic that lead this thing, that have staff all these positions and handle complaints, that have no understanding of the racial diversity, the Black and racialized diversity of this country and the experiences, then you're going to have failure when it comes to meeting those people's needs. A change like this would precipitate, I would think, that whole notion of ensuring that there is transparency and accountability that can now be built in, that is reflective of the Canadian mosaic. That can't be done now because it's all the same people. They don't see anything wrong with the commission. They're just trying to tweak it. So really, that's really what it is. It's really about a fundamental revamp of make sure that you have the right people input, people who understand anti-oppression, anti-racism, and have that lived experience. If it reflects Canada with all of our imperfections, then I think we'll make a perfect institution to address human rights issues within this country.
Thank you.
Thank you, Senator Joe.
Madame la Présidente.
Thank you, Madam Chair. I've been listening to you and also to the witnesses that appeared before. Can everyone hear me? So I listened to the previous witnesses and then I listened to you, and I get the impression that really there's no trust. The relationship of trust that existed is broken. There are incredible delays processing complaints. The victims often have to wait an insane amount of time to get access to a remedy. So do you still trust the commission at all? And if so, what type of reform do you think needs to be made? And if you want to have an equity commissioner, would you imagine both of these things happening at once? So first of all, reforming the commission, and then secondly, having this commissioner who would be in direct contact with the complainants. And how do you see that working? Can we reform the commission? Or should we completely let the commission collapse, just throw it out? Because it is as bad as everyone has been saying. So what's your view on that?
I begin? Merci beaucoup. What I would say first of all is that I think it's important that the commission be stopped in its mandate at this moment and that there be a transitional phase to enable a tribunal-based model to come into effect. We have the recommendations from the Laforêt report, which are attached to my submission going back to 2000. We have the examples from Ontario, from the Cornish report, from the ultimate mechanisms that gave rise to the 2008 implementation of the Ontario Tribunal, and we have the situation in BC. So it's not like we're without examples of how to do this. Yes, there may be a need for some level of transition, but I don't believe the present situation is tenable. And so there needs to be a rapid transition that, at the one hand, enables a tribunal-based model to arise, and on the other, lets fall, as you indicate, the present commission model, and enables it to be reformed and replaced with a differently resourced, differently structured model that has a different mandate in the ways I've tried to describe before.
Thank you, Senator. To put it very clear, we do not have any trust in the Canadian Human Rights Commission to deliver justice, to deliver its mandate. It has demonstrated over decades that it has failed. It has failed particularly Black Canadians in terms of executing its mandate under the prescribed legislation. And the only way to move forward is to have this direct access model in addition to other systemic remedies, such as amendments to the Employment Equity Act, such as other accountability measures, such as the Black Equity Commissioner. But I have to say it again, we have no confidence in the Canadian Human Rights Commission. Thank you.
Yes, and I agree with the comments of my fellow panelists, but again, I have to go back to my comments. I don't think that this is just a failings of the Canadian Human Rights Commission. This is an institutional failure across institutions that enable the Canadian Human Rights Commission to have continued to do what it's been doing and not serving Canadians, Black and racialized communities for decades. Canadians have been calling out to leaders and bureaucrats for decades. And so the fact that this has been allowed to continue speaks to the need for a review or some kind of study or a national inquiry that allows us to look at how anti-Black racism manifests and is perpetuated across institutions. If we just use, the Canadian Human Rights Commission as the fall guy here, we throw them under the bus, it was there and we'll fix that, and then think that for a second that anti-Black racism will be rooted and will be addressed for the government of Canada and for all of us as Canadians, we are sorely mistaken. We need to look at the whole thing. And if you follow the paper trail, which I tried to make sure there wasn't a paper trail actually in my dealings with government over my time, but if you follow the leaders, you will find that everyone knew about what was happening and that the failures were deep and institutional. So you need to have a comprehensive response in how you deal with this. Or you're just going to have something similar like this happen in another department. So again, yes, for sure, we can look at, making reforms to that institution. But that's not what the real problem is. The problem is how we think about Black people in this country and how we're not being ambitious in addressing the generational slide that we're seeing in all of these different disciplines That's another Senate hearing, I think, senators. That's another Senate hearing about how Black people are faring in this country worse and worse after generation. But that's not just the commission's fault. That's on us and my kids and my child who's here. Her future is in jeopardy here in this country. And I have to think long and hard about that. So I think a conversation needs to be broader. We need to be more ambitious about this fix, not just being about the commission, but all of our institutions that touch the lives of Black people.
Can I make one comment about that, if I could? Canada arguably has one of the best models of human rights deliberation and adjudication on paper in the world. So does Russia. So does China. So do other regimes from years past. But the reality is they have not and they do not work to resolve the problems of institutional racism, of systemic barriers, and of enabling a system to redress the real wrongs experienced by communities. And it's not enough simply to have policies and objectives without measurable results. And what we see, we have measurable results, and they are an abysmal failure.
Thank you.
Is it okay?
No, please, sorry. No, I don't think we have time for second round even. In fact, I hate to break the news to you, but the 20-minute break has now become a 10-minute break. But what we are hearing is so compelling, and I wish we had more time. And Mr. Chair, I agree with you. If we can have all the policies we want on paper, but if they are not implemented, it's a useless piece of paper. So thank you for raising that point. I want to talk about that in October of 2022, the Commission released its Anti-Racism Action Plan, the Progress Report, which outlines the actions taken by the Commission under its original plan, the outcomes achieved, and the future steps that will be pursued. Your assessment of that plan, and what impact did that have externally and internally?
I'll begin, and just briefly, I had a look at the plan and the report, and the report demonstrates the clear flaws in the system. For example, the report states that the Commission is meeting all of its targets on employment equity. Nothing further.
Yes, Mr. Sharp, Mr. Shea, would you like to?
I think it's another example of having clearly stated objectives and a paper trail that reflects those objectives, but the results are not meaningfully being measured, and the falling through the cracks is not effectively addressed. It's effectively whitewashing the reality of the experience, both for Black Canadians at the Commission and for others. It's not limited to Black Canadians. I mean, can I just give you one quick example in terms of the problem? I represented this disabled woman at the Commission. The complaint was originally filed in 2000. She lost her job. This was against Canadian National for a failure to accommodate a person with a disability. Her job was lost in 2005. Okay, 5 years into the complaint investigation process. The first Human Rights Commission investigation report found against my client on every issue of fact and law. And the Commission dismissed the complaint. We judicially reviewed the matter. And about a year later, the federal court found that the Commission was justified. I appealed that to a 3-member panel of the Federal Court of Appeal, and 2 years later, the 3-member panel of the Federal Court of Appeal reviewed what we had said about the lack of thoroughness, the lack of comprehensiveness, the failure to address all the 15 things we said that the investigation missed, and ordered that the matter be referred back for a new investigation by a new investigator. And then subsequently, that investigation was then carried out. It found in favor of my client on every issue of fact and law, and recommended that the matter be referred to tribunal. Thereafter, the employer sought to judicially review the process, saying that, well, too much time has passed now. We can't possibly get a fair hearing. And since that time, there was a hearing process that took place, after the federal court of appeal that took a while before, a year before it started. It went on over a period of 2 to 3 years, broken up in days of hearing here and there. Closing arguments were in October of 2019. We're still now in April 2023. We've yet to receive a decision. The main defense on the claim was prejudice due to delay from the outset. We are now 3 years after closing arguments. We have no decision. How can we even possibly meaningfully review a negative outcome 3 years after the fact of closing arguments, and now 15 to 20 years after the time of the original subject matter of the complaint? The system is broken beyond repair, with all due respect.
Mr. Sharp, would you?
Just very quickly, I spent a greater part of my career in the public service working on developing performance measurement frameworks for one of the largest departments in the federal public service. We can develop lots of frameworks and action plans that don't do diddly. We need to be able to make sure that when we're developing these frameworks, we have particular outcomes in mind, and then when we're achieving those outcomes, we use those frameworks to measure how well we're doing against them. After 3 years of developing a framework, what are the outcomes for Black and racialized Canadians? What are the intended outcomes? How is that going to be achieved? So I say that because some of our institutions like to develop frameworks and action plans, but not necessarily achieve results for Canadians. I like the results piece better, and then you work backwards and make the framework. I guess that's what I'm doing in my day job right now. So it's much more satisfying when we actually achieve results for people.
I don't know how many of you can see Senator Umidwar is literally begging me, so how can I refuse?
So I have a
Very quickly, very
big
briefly.
question. You have asked for to halt and revoke the mandate of the CIC, Canadian Human Rights Commission, and because you have no confidence. Do you believe other racialized groups are in allyship with you on this recommendation?
I would think that they are, but I think their experience is fundamentally different than the unique experience of Black Canadians, having regard to the history and the broad-based experience of Black Canadians in terms of anti-Black racism historically and throughout modern institutions. I think it's a different experience. So I think it's a bit of it's similar to the argument with regard to the Employment Equity Act regarding visible minority categories, or the visible minority category, excuse me. So there are certain ethnic groups within that group who have fared better. Right?
We know that, and some don't.
And again, when you aggregate them all together, right, you get a misleading picture. And that's what the government has historically done. They aggregate them all together so as to suggest that the results are better than they actually are. If you look more deeply into the results, for example, with regard to promotion, there was a 2019 promotion rate study done across the federal public service over a period of 27 years. And in the 10-year period for which data was produced relative to that study, relative to subgroup Black Canadians, it demonstrated it's a minus 4.8 promotion rate differential as between Black Canadians in the public service and others. So there's clearly a demarcated difference. So yet nevertheless, the government in its study suggests that there's nothing to see here, but they don't reference any of the subgroup data because they say, well, that's not the mandate of the act. With all due respect, that fundamentally negates the reality of employment equity, which is to identify and remove barriers to the full participation of all those who are addressed within the act. And the need is spoken to there for a specific target relative to Black Canadians because of their experience and history, and the need to ensure measurable results that are favorable and positive, as opposed to just simply being washed under.
Thank you, Mr. Chair. Mr. Sharp, really quickly, because I have my other colleague who's begging me. So senators, what's going to happen? What was a 20-minute break that became a 10-minute break will now be a 3-minute break. But I'll let Senator Gerber ask a question.
I have a lot of respect for this tough chair. The words of a colleague, former colleague, Martin Nicholas, is ringing through my ears. We have something in Canada called substantive equality. So with substantive equality, you can break down and you can hear the voices and look at the data for subgroups of the employment equity group, which are Black people. So with all due respect to all the other groups, based on the data, based on the lived experience, regardless of what other groups are saying, for the Black communities in this country, that system, the system of the commission, does not work, and I don't think was ever intended to work for us. So yeah, demolishing and rebuilding, absolutely necessary if we're going to have confidence built back into those systems from these communities.
Thank you, Senator. Really quickly and briefly.
Oui, très rapidement, vous êtes
Yes, very briefly. You're a lawyer, a public servant. Now, there are forms for voluntary disclosure that exist in some of these contexts where you can declare your race, your ethnic group, your gender. A lot of people are against that type of declaration. What is your point of view, when it comes to recruitment, promotion, that sort of thing? Is this useful or is it discriminatory?
I would say that I don't believe that it's discriminatory. I think it's important and essential in order to identify the nature of the group and the experience of the particular group, whether it's, Black individuals, South Asian individuals, disabled individuals. If we don't have an identification of the group, it's hard as a group to monitor and to measure results tangibly. It also enables a policy-making function, which is to ensure that measures can be put in place to address specific needs, identify specific barriers, and try to resolve and eliminate barriers as part of a barrier removal process. So I think it's essential. I don't know how else to do it. So for those reasons, I don't know that there's any other alternative.
It is absolutely necessary, the collection of data. The challenge is that in the past, it has been used in a discriminatory manner. So there is a lack of trust in terms of the collection and how disaggregated data is used, but it is absolutely necessary if we are to understand where each group is, which group needs some help, which group needs more help. It is critical, but there's a serious trust factor in terms of making that declaration. Workers have told me they do not fill out those because they do not want to be identified. They do not want to face any type of discrimination, and that has been their experience.
Yeah, this has been a bee in my bonnet for a very long time. Yes, we need to collect the socio-demographic data, the employment equity data, but the whole self-ID concept is completely flawed. It makes people feel like they're doing something wrong. It makes people feel like they're exposing themselves. And so that is reflective in the low uptake of self-identification within sort of federal institutions. With respects to not wanting to be identified, I often say this, and I know it's not the same for other equity-seeking groups, but if I don't identify as Black or racialized, I think people still see me as Black, racialized. I'm still Black, and I get discriminated against because of my color, irrespective of whether or not. So, but if I want to avail myself of positive measures to support my advancement, I have to tick a box that makes me feel uncomfortable to tick that box, but I will be discriminated against because people see me. So, I think that for another discussion, we need to come up with different ways of quantifying the existence and the participation of racialized people in our workplaces. I think the self-ID thing has been a complete failure. And so I know conversations with Statistics Canada over the years have been talking about using the census, using demographic modeling to help us identify the numbers and where people are in the workplace. But it takes time, takes some effort in terms of those tools. But I think we can do that. We're creative enough. We're human beings. We're always creating things. But I think that the self-ID thing is bound to continue to fail us because when not enough people self-identify, people say, well, not enough people are self-identifying. We couldn't actually count people properly. So I guess we'll just keep doing what we've always been doing. So it's very much an instance of us having to create something different and being creative and using the technologies that we have at our disposal to revamp, like we're doing with the commission, like I think we are going to revamp the commission, that we revamp this notion of self-ID so that it's something that is more of a data collection methodology that allows us to quantify people's participation in the workplace without having to force them to make them feel that I'm identifying and making myself vulnerable by ticking that box.
Can I make one more comment, which I think is important? It's not just about the self-ID, but I'm reminded of the Ontario employment equity experience. And when we had, for example, targeted hiring targets for particular ethnic groups, and when we had, for example, the need to identify in that regard, and the perception that somehow members of these groups who were subject to these hiring targets were being given a benefit over others. In other words, Black people were being able to take positions that would otherwise be available for others, including whites, and whites were effectively being barred from the door. These are serious perception concerns. There's serious substantive concerns that need to be addressed. And I think they go along with the notion of self-identification in terms of how employment equity and substantive equality are understood and how they're applied in Canada as something more than notional or something more than a policy on paper. So I hope that's of some help as well. Thank you.
Gentlemen, I want to thank you for your testimony. You've given us a lot to think about, and your testimony will help us when we write the report and we write the recommendations. And we had a very successful spot study last time, and I'm hoping that this spot study will have the same success.